Good morning. May it please the court. Juan Valdez on behalf of the appellant Coral Way Condominium Investments, Inc.
Good morning, counsel.
We're here seeking the reversal of a summary judgment.
Would you like to save some time for rebuttal?
Yes, I'd like to reserve 2 minutes. 2 minutes. We're here seeking the reversal of a summary judgment granted to the association, 2122 Condominium Association, regarding its foreclosure of 6 claim of liens.
Didn't you get into this case too late?
I'm sorry, Your Honor?
Weren't you required to challenge the sufficiency of the underlying cause of the lien when the lien was being imposed? Not now.
Well, Your Honor, the association controls 89% of the...
All of that doesn't matter.
Well, we feel that it does matter, Your Honor, because if the association controls 89% of the units and they have sufficient votes to pass any measure, it doesn't matter if we appear at a meeting and oppose the measure, they're going to pass it.
But that's what the bylaws say. If there's a majority of directors and that they want to pass and they follow, there's nothing that says that they did a special meeting, the notice was sent properly. I mean, they did follow the procedure set under the bylaws, correct?
Yes, they did follow the procedures under the bylaws.
So then what's the basis of the claim?
Well,
the only thing you can do is say, they overspent, it shouldn't have been, it was a stupid appropriation.
Well,
That's what the bylaws are for, to make those determinations. And you can't, after the bylaws have been fully complied with and everything is okay, then you say you shouldn't have assessed that lien. They did assess the lien and they did it appropriately.
well, they passed the measure appropriately, but the basis for that lien is inappropriate, Your Honor. What we're claiming
What
is
case
that...
do you rely on that says that this is a possible means of attacking the underlying appropriation?
Well, to address that matter, Your Honor, what many people forget is an association
Well,
at the end of the...
first of all, what case do you rely on, if any?
We rely on 3 cases, Your Honor, which is the Biltmore Motors Corporation versus Roque, the Tillis versus United Parts, and the Tillis, the Roland V. Times Publishing case. Those cases, although not in the context of a condominium association, regard the action taken by corporate officers.
Right, but here, I mean, we have, there's a reason why we actually have a statute that controls condominium associations. There's a whole statutory scheme for how condominiums are supposed to be run by associations, and they're governed by the specific statute. And not paying a valid assessment, whether or not you agree with it or disagree with it, is not an appropriate way. You still have to pay it, and if you want to challenge it, you could file a breach of fiduciary duty, or you could file something in court. It's the same thing as if you have a landlord-tenant situation, and you say, my landlord is not taking care of certain things, I'm not going to pay the rent. Well, you have to pay the rent, and you could pay it into the court registry.
Well, here, Your Honor, to kind of address that issue, at the end of the day, my client did post up a bond, and we have raised a counterclaim for breach of fiduciary duty on behalf of the association and its officers and directors. However, the lower court has stayed our counterclaim and refused to hear both cases together and granted the summary judgment and refusing us to present our case on breach of fiduciary duty.
Let me straighten something out that I'm confused on.
Sure.
Was there any evidence or any allegation below that the assessment, in fact, the money for that special assessment, was not needed or used for the elevator itself? Now, listen closely to my question, because I know what your allegations are. Was there anything presented below that whatever it was, which was a substantial amount of money,
Correct.
the assessment was not necessary to repair the elevator, which is a common element?
The assessment itself was used to pay for the elevator repairs.
Right. So then your argument, the way I understand it, is that this would not have been necessary had they not used other assessments to pay for repairs, et cetera, that weren't common elements.
Correct, Your Honor.
So you have 2 separate issues. You have a breach of fiduciary duty on the money that's been used before, but you have an issue which a judge granted a summary judgment on, saying as to the elevators, you haven't shown me anything but that there was an assessment, you agree that money was necessary and used for the elevators, therefore you were obligated to pay.
Well, the appeal here is on the granting of the summary judgment.
Right.
Yes.
In order
Right.
to grant a summary judgment, there must be no genuine issues
That's
of
what I'm
material
telling you.
fact.
There is no genuine issue of material fact because your allegation was the money was asked, the money was used for the elevator, which is a common element. There's no dispute. So there's no issue of material fact. The other issue you have is other monies we paid were used for private offices and repairs, et cetera. That's a different breach of fiduciary duty. So on the summary judgment, I don't see a material issue of fact.
Well, in addition to proving that there's no genuine issue of material fact, the lower court must also draw all reasonable inferences in favor of the
But
non-moving
what's,
party.
what's the
are they?
material
What are
fact?
they?
The reasonable inference would be that but for the improper payments made by the association to maintain and repair the non-common area elements, the association
but
would have had
this is where-
sufficient
where-
funds
where does-
That's
to
not
pay for the
relevant.
special.
Where is it say, because the way I read what your arguments are, is that they have to have some kind of emergency fund, basically. That they should have had these funds, they should not have used them in a particular way, and then they wouldn't have had to do this assessment in order to repair the elevator, which is a common element. And the question is, what cases do you have that support that? Because there is nothing, I saw no case that supports that position. And so the question again is, it's a valid assessment. They followed proper procedure. They held a meeting. They sent out the notice properly. And it was clear that they used the assessment to repair the elevator, which is a common element. And your clients are not entitled not to pay the assessment because they think they should have had an emergency fund.
Well, we're not claiming that the association is required to maintain an emergency fund, but what we're saying is, had those improper payments not been made, the association could have had sufficient funds
And what
to pay
case,
for.
what case or anything?
There
Any
are no
authority
cases on point that
Do you
would
have,
require that.
well, think there might be a reason for that?
Well, Your Honor, we feel that it's an issue that hasn't been addressed yet, and we feel that it's unfair and inequitable to have a majority owner pass a measure when, but for their actions that were to their benefit, depleted association funds, and put the minority owner to the detriment.
And as a result of that, you don't have to pay for the elevator.
Well, and we're not saying that we don't have to pay for the elevator, but what we're saying is that it's a reasonable inference that could be drawn that precludes the motion for summary judgment from being granted, and therefore, all the issues
There's a
should be tried
reasonable
together
inference.
at trial.
Of a material fact, namely whether you have to pay for the elevator.
There's a genuine issue as to material fact as
That's
to
what
whether
you're
or not.
saying. That's what you're saying.
Right,
This is
there's an issue as to whether or not the
Somehow
association should have had funds.
There's some, you may detect a note of questioning the validity of that position.
Yes, Your Honor. Our position is that the summary judgment should not have been granted at this time. It was premature. There's genuine issues of material fact, and all reasonable inferences should be drawn in favor of my client, which show that but for the payment of the association's improper payments, they would have had sufficient funds to pay for the elevator modernization that they claim to have been an emergency.
So you don't have to pay for these.
We're not saying that we don't have to pay for the assessment. We're saying that we shouldn't
So
have to
that
pay
you-
for it at this time
So you don't
until.
have to pay for the assessment? That's what the bottom line is. That's why we're here. Because you haven't paid and don't want to pay the assessment.
Well, we don't want to pay the assessment if there's other issues that result as a setup. As the lower court said, the lower court said that we have
You
issues.
don't want to pay the assessment.
We don't want to pay the
You say that there's a
assessment.
good reason that you shouldn't pay.
We don't want to pay
and-
the assessment if the association acted improperly.
You don't want to pay the assessment.
Yes, Your Honor. We don't want to pay the assessment if the association acted
You don't
improperly.
want to pay the assessment even if they did answer. But the law requires that you do.
Well, I wouldn't agree with that position, Your Honor, because I'm saying
Okay.
that there should have been.
Counsel,
Thank
we
you.
understand each other, don't we?
We understand your argument,
Okay.
counsel. Thank you very
Thank
much.
you.
Counsel?
May it please the court. My name is Greg Beck. I represent the Association 2122 Condominium Association. I think Your Honors have identified the issues here. The association properly passed a special assessment for the purposes of modernizing and also some flood damage repair to the two elevators in this condominium. And they did it within the confines of the governing documents as well as Florida law. And unfortunately, these folks decided that they weren't going to pay it and brought up, as you all said, distinct issues associated with other expenses that they weren't happy about as a means not to pay. And of course, there is no legal support for that, and the lower court agreed with us when we filed our motion for summary judgment. So unless you all have any questions, I'm just going to say we would ask that you all affirm the lower court's granting of summary judgment and direct a sale forthwith.
Thank you, counsel.
Thank you.
You have anything else, counsel?
No.
Thank you
Thank
very